Hey, everybody, we're back. We have just a little bit of time, roughly 8 minutes with Mike Jacobs. So I'm not going to say much. Mike, what happened today? And my central question was, I thought the amicus request would be a slam dunk. What's going on? Or am I wrong? Am I right or wrong?
Yeah, you're right in that typically an amicus request is granted. There usually isn't a lot of eyebrow raising about those types of things when people want to engage as a in that capacity. Obviously, that wasn't the case today, and the judge hadn't uh, seen the opposition documents from the city and the port and the A's that were filed. Um, there's typically a lot more time to deal with these types of things, but because of the streamlining that's applied to this case, um, everything's on an accelerated timeline. So, the Communities for a Better Environment, when they submitted their proposed brief and their application to submit, had to do that on a very quick timeline. And the response also was incredibly quick as well. Um, I think what happened today from the judge, you saw a pretty deliberative approach to it, given the time constraints. He wants to have everything wrapped up by the time the hearing happens, which was rescheduled for September 2nd.
For a second.
Yeah.
What about his comment, or not his comment, but the opposing attorney representing, it wasn't the athletics, but it was the lady's name, I forgot.
For
But
the city?
yeah, for the city. She said that, or she made the allegation, for want of a better term, that the amicus brief by communities was something that looked like it was planned as opposed to coming spontaneously, which is kind of an interesting play on words. But how did that come about? Or was she right or wrong?
Yeah, there's a lot of ways to participate in these cases. And, you know, just as PMSA ourselves, we've been an amicus party in multiple cases over the years at the trial court level in California Superior Courts. Um, and when you kind of move in at that level, um, obviously what you're intending to do is to provide an additional voice at the table. You can expand the basis for the evidence being brought in front of a judge. You can expand the number of issues that are being brought in front of the judge, but you can bring your voice. And it's a way of essentially saying, we have some skin in the game without being a full litigant. Um, so it's a really kind of narrow and specialized area of the law. But typically, what happens is um, those types of applications to appear get approved because there aren't a lot of good reasons not to. And I think what you heard from the city was a lot of fear that there were going to be new things that were added to the record or new arguments that were brought to bear or things of that nature. And I think what you heard from the judge was, I think I can handle it. Please just let me know what the scope of your complaints and considerations are, and I'll take them under advisement. Um, you know, the the issues in front of the court in this, are extensive. The record is huge. Um, there are not enough pages to brief everything that everyone wants to brief on both sides of this uh, uh, question. And so, of course, there's going to be a lot of back and forth. And I think you heard some of that today about, how many pages have already been filed and, how much reading there already has. There's hundreds of thousands of pages in the record associated with the development of the CIR. So, that there's not a shortage of potential materials or things to get hung up on. And I think if you were hearing from the city, one thing, what they're potentially afraid of is they're afraid that that somehow by bringing in other folks as amicus parties that the process will lose its focus on the narrow claims that we were able to bring as petitioners. I don't think that that's a good reason not to include an amicus party. And, I think we all know that, especially the judge that we have that's used to dealing with very complex civil litigation, probably has a pretty good handle on it, especially since he asked the parties, tell us where you think I should put in some safety railings. And if I let this in. So, but all in all, I would be shocked if he doesn't approve the Communities for a Better Environment amicus.
Now, unless my hearing was bad, I believe the representative for communities used the term offended or offensive when it was their time to speak. What about that?
Yeah, I think she was, reacting to those comments from the city and from the A's regarding, the exclusion, and the position that they're bringing obviously is one of representing environmental justice communities. And I think she was essentially saying, if you don't think we have a voice at the table that's worth hearing, that's offensive to those communities.
That's what I thought I heard. Yeah, definitely.
Yeah.
But the bigger news is that you got your hearing. I mean, it could have been dismissed, right?
Well,
Not that it would have been. I'm just saying.
What's going to come next is the hearing itself in chief is moved to the second.
Mm-hmm.
We're actually happy that the judge spelled out exactly what the process was going to be moving forward, that he's going to issue a tentative relatively early. In a lot of cases in Superior Court, you won't see a tentative ruling until the day before the hearing. And Judge Seligman in this case said he's going to try to get it out maybe a week or maybe even several days ahead of that hearing to give everyone some space to respond and to craft their arguments, so they're really tailored to his questions and his points of where he sees a potential ruling going. Tentatives don't always get you don't always go with the tentative, but most of the time.
Point of information for my non-lawyer viewers or people who didn't come close to going to law school. Do you tell them what a tentative?
Oh yeah. So when a judge gives you a tentative ruling, that is essentially the initial response to whatever your claim is, and it can tell you exactly what they're planning on doing, or it can give you an idea of what they're doing, or it can help you craft your arguments in the hearing. It can say, I was persuaded by these parts of your argument. I was not persuaded by these parts of the argument. Or it can say, these parts of an argument are a slam dunk. Don't waste your time on those. I'm going to rule on those separately, but I really want to hear more about this. So it's going to court is not usually an iterative process with the judge, right? You're just giving them a lot of information. But a tentative ruling is a place where they can actually provide some feedback to you before a hearing, so people aren't wasting their time and they know what approach that judge is taking towards getting a resolution. And like I said, sometimes, a tentative ruling can basically say, here's what I'm going to rule on unless you tell me otherwise. And that happens a lot, right? So you'll go through a public hearing and at the end they'll say, okay, well, I'm going to go ahead and enter, my tentative.
And that happens with the Raiders, I remember.
Yeah, that happens a lot, but it doesn't have to be like that. And so you don't really know until you see it. But we were happy that obviously the judge is going through all of the briefings. He's being very specific and deliberative about what he's considering, and he's going to try to give all the parties enough time to really digest his position and his proposed tentative, and that's a really good thing for everybody.
Oh, real quick, who's the judge, by the way? What's his name?
Judge Seligman.
Seligman.
Yeah, been on the bench for a long time, very highly respected jurist, and I think, as you can see from just today's hearing, he's got a good grasp of the fact that this is a big, a big item. It's got a lot of different people involved, a lot of different voices at the table, and that he's going to be eminently fair in handling it. So,
Do you sense that he's under any pressure to get this done on a fast track because of the overall fast track nature of the project?
no, he definitely is, and we're all very aware of the fast track statute. Um, you know, I just the entire thing that happened today with the amicus, um, you know, trying to fit it in this box. You know, I think you heard from, you know, both sides saying, you know, when you're dealing with discretionary action like this under the time constraints that we're looking at, um, that people are being very mindful of the fact that we're trying to fit this as kind of a square peg in a round hole. Um, so, but that doesn't mean you know, as far as we're concerned, that doesn't mean you shouldn't have access to the court. It doesn't mean you should be acting on the substance any different than you would otherwise. I think our interpretation of the fast tracking statute is that, you know, everything has to be wrapped in a certain amount of time, but in the meantime, we wouldn't expect people to not have the same type of access to the substantive arguments they'd otherwise be able to bring to the table.
I'll let you go in a few seconds, but one last question. Dave Cobble made a comment that the lawsuits are actually slowing down the process, but can't the city, for example, begin the process of, well, approving the creation of the public financing authority and starting the writing the infrastructure financing plan and fast tracking its hearings, like, for example, with the State Lands Commission? Couldn't they ask for a special hearing to move everything up if they wanted to?
Yeah, I mean, I think you know the answer to a lot of that is that uh, there's a lot of background work that could be happening now, that is happening now, and that should be happening. The linchpin for all of this, really, though, is an approved EIR, and so keying the rest of those development agreement considerations, those discretionary approvals down the line on the EIR, obviously very important. But to your point, that doesn't mean there weren't other things that could have been done first. And you know, the, the fact of the matter is that the litigation point is not in and of itself a delay. They
Right.
passed this bill that said, here's what the timeline for the litigation is. So they've already built the litigation into their timeline. There's no delay here that they were not expecting and they haven't already accounted for.
See, that's my contention with this entire project. And I've said to the mayor that they don't have a fast track timeline, and they almost seem, well, to me it seems like they're going through it in a piecemeal fashion, picking up things along the way. Because first you had the project manager, not to prolong this out of respect for your time, saying, well, we're not going to use SB 293 Skinner, but not explaining why. Dave says we're going to use it. Then they go back, the term sheet that was supposedly rejected by the A's, they just got to a point where they're still negotiating it a year later. Right? A year later.
Yep.
I repeat, a year later. Am I missing something here?
We might still be going, I mean, who knows?
And meanwhile, Phil Ruffin, the owner of the Treasure Island, which is actually a pretty nice hotel, is or has entertained the meeting with the Athletics. To what outcome, I don't know. I actually have a request in to interview Mr. Ruffin. Fingers crossed it comes through. But I got a hold of the right people, and they're very nice to me. So that's half the battle. And then he was supposedly in Oakland a week and a half ago, 2 weeks ago. So all that is marching forward. If it turns out that the A's are gone, what do you guys want to do?
I don't know. Where we are right now, and maybe just to wrap up today, I mean, I think the real question is if they're going to stay, what's the total price tag? What are the mitigation measures? How are they going to do this project right? This project is exceptionally complex. There's a lot of stakeholders at the table. And if you're going to see the type of fight you are just about whether or not community members can get to the table in court, I can imagine that same thing is going to happen when they show up and they've got their hands out and they're saying this community benefits agreement isn't good enough. someone's going to have to step up and broker a deal, and they're not doing that yet.
Wow, if that happens, I will consider this project a major disaster beyond the timeline issue, because that's something that we talked about this before that should have been baked in the process, and I assumed was, given the way the legislation was written. You guys could have been taken care of and made whole. The mayor could have done that, and the project manager could have done it too, but the project manager didn't know how. And I look, this is not a matter of personalities or how I feel about people on a regular basis. I love them all. This is about getting something done right for a city that's in trouble. And there's my soapbox. Sorry.
Thank you. Mike. Appreciate the time today.
Thank you, Mike.
All right.
Okay. See ya. All right. Hey, folks. Well, that's Mike Jacob. He explained, for those of you, rushing to catch up, earlier today, preliminary hearing was held at Alameda County Superior Court by Judge Seligman, and the basic decision that came out of that event was that the hearing date was moved to September 2nd, and that they would then take up the final resolution of the addition of what is called an amicus brief. Amicus simply means friend of the court. And a friend of the court brief can be filed at what the defense, what the other side would commonly argue as at the last minute, but it doesn't preclude the ability to add it. It is just one more voice. Now, what doesn't make a difference in this instance depends on what they say. I don't know. But the main question is still outstanding. Will the judge allow it? And it should have been a slam dunk just by the way these parts of the legal process go, but it wasn't. And the judge left hanging out there for anybody to chew on why it was really necessary to have at the last minute. And so it's going to be interesting to see what happens on the second and where all this goes. And within that, where all this goes, what the judge's tentative ruling is going to be. I can't pretend to know the answer to that question, but given what, I'll just be blunt with you, given what I heard this morning, it sounded like somebody had been maybe slightly influenced by my comment that this whole lawsuit was frivolous. And Mike's my friend, right? But Mike's got to do what he feels is in the best interest of his clients. And as he said, many times his interest is in stopping Howard Terminal. Okay, they're not really desirous of something that gives them, a truck stop here or this there. They prefer the new athletics stadium be built on Coliseum grounds rather than there. And that goes along with an entire fear that if you come along, and it's the Disneyland dynamic. What do I mean by that? Well, when Disneyland was first proposed and built, it was in the middle of a gigantic acres and acres and acres field of orange groves. What happened after Disneyland was open and the flood tide of tourists came in was that field of orange groves was converted into, gas stations, hotels, housing, offices, development to take advantage of the fact that because people were coming to that land because of Disneyland, that Anaheim was a place to be, known by the world, and therefore a destination to live, work, and play. Well, similarly, what could happen in the case of Howard Terminal is the athletics draw more people down to the ballpark than ever before because it's new, It has a novelty factor which draws tourists. And so it changes the entire dynamic of how the population, not just of Oakland, but the Bay Area and America and the world, responds to that part of Oakland. In the same way that Fisherman's Wharf impacts San Francisco as a tourist destination, arguably Howard Terminal will impact Oakland. And so there will be interests to outbid current industrial uses for what is perceived to be a higher and better use related to tourism over time. And that is not what the maritime people want. Okay. And it would impact Oakland's economy in a way that arguably would be negative because we don't have a plan that points for that kind of transition. And so if and when it happens, it will be an ugly one in that we would not have enough hotels to handle the tourists. The tourists would go someplace else. They would be a kind of a boomerang demand for more hotels in San Francisco, which is just across the bay. Because Oakland didn't have its development act together with respect to building more hotels. We are under the amount of hotels we need as a region by 16,000 rooms right now, roughly 20,000 rooms right now as it is. And Oakland's recent addition is basically a pop gun is not basically, it is a pop gun response to an overall problem. Okay. Oakland alone would benefit by having 5,000 more hotel rooms, like, for example, the 1,100 room double wing development concept that I came up with for my idea for a new Raiders stadium or a new NFL stadium at the Coliseum, called Coliseum Reboot. Coliseum Reboot. Just type Coliseum Reboot in Google, comes up number one. Click on it. That's the website. It's still available for view and visit to this day. But I digress. The place we're at right now is this really is a battle for the future. Because what happens here will dictate the future of the waterfront. That's outright given. I favor Howard Terminal, but I also favor a middle ground. I think that, I've said it before and I'll say it again, that there's enough tax increment money to not only sustain, but to enhance the development of the maritime industry, even with Howard Terminal. Okay. And I don't think the current plan right now reflects that. Well, it doesn't, because where's the new truck stop? I don't see it. Where's the necessary systems, to merge these two interests, right? Why can't the maritime people have a convention center nearby for, say, hey, Caterpillar trailers and all that sort of to have a convention, right? None of that was effectively done because it's not penciled out and included in the infrastructure financing plan, because the city has never written it, because the city never established the public financing authority, which by law would approve will call for the plan by vote and then approve it when it's done. We are way behind schedule. And so while we're, fooling around, the A's in Major League Baseball they're not going to wait, because this is a major juncture for them too. The A's need the money, and there isn't anybody that's paying them a gigantic wad of several billion, to allow them to wait to get something done in Oakland. Something's got to give. And it's more and more looking like that something is going to be a move to Las Vegas. But what bothers me is that, just like the Raiders, there are people who got after me about not agreeing with the position of Forever Oakland. And I didn't disagree with it. I wanted the Raiders to stay. I simply held that name and colors was a pipe dream to get in court, given the legal ownership of name and colors the Raiders had this year compared with years past, or even 5 years ago. That's all I was saying. But there's some people who feel like you have to agree with everything they say 100% or you're not a friend. And that's simply not true. Okay, that is simply not true. And I didn't vehemently disagree with it, but I'm entitled to what I feel is a more reasoned approach. I believed then, and I still believe now, that the best revenge is success. We have people who hate the Raiders because they moved. I understand that. And they don't want to watch football, but then they wind up doing it. And they wind up falling the familiar trap of being forced by their own emotions to root for the team if the team happens to be successful someplace else. Well, why not another approach? Why not start a whole new brand, slightly based on the Raiders, but focused on Oakland, that is designed around the unique needs of our city? All right? My point is, we're losers, in my opinion, if we continue on a path that results in us not doing anything to replace the Raiders. And right now, that's the path that we've been on. That's not what we did in the past. When the Raiders left for Los Angeles, what did we do? We sought a way to replace them. That way became the USFL. We didn't think that expansion was open to us with the NFL. Then the Raiders wanted to come back. Today, we haven't done anything. As I said in the previous broadcast, when you ask the mayor of Oakland about bringing the NFL back, she says no, and her reasons are personal. She says that the NFL basically did the R thing to her, okay? Her words on my show. Blurted out the term rape. Now, I agree that Mark Davis was not the best at showing Libby respect, but the simple fact of the matter is the commissioner of the NFL was, and the mayor made a number of mistakes. The biggest mistake of all is that the mayor made retaining the Raiders about her. She put her face on it. Similarly, she's putting her face on Howard Terminal, so we have no plan of succession. Let me ask you, who takes over as the face of Howard Terminal messaging when Libby is termed out, assuming, of course, by then, officially, the Athletics haven't announced that they're headed to Las Vegas. When I asked her that question, she said, maybe Ed Reskin, the city administrator. In other words, she had to put a qualifier, all right? She had to put a qualifier on the whole thing. She did not have a plan for succession. That in and of itself is alarming. Okay, that's purely and simply bad planning. Okay, you don't have a plan of succession for this thing at all. It's bad planning. But the city doesn't, and this is happening right now before our eyes. This isn't something that you can look back on and say, "Well, gee, they didn't have a plan of succession." They don't have one, and it's in the middle of this entire process of presumably finishing Howard Terminal, when it feels more like to me that the city is stopped. Okay? But the mayor has made herself the face. She's insisted on being the spokesperson, insisting on having the comments, right or wrong regarding the technicalities. And they've been wrong about half the time. It's embarrassing. It's embarrassing for the city. It's embarrassing for people who have been longtime friends of the mayor, who know the mayor can do better, who want the mayor to be the mayor. But, okay. But, and it's embarrassing to the legacy of sports in the Bay Area, and in particular Oakland, to have something that many of us believe would never happen be close to happening, and that is a place where we've lost all three of our professional sports teams. But my point is, losing them is not the real problem. It's not trying to get sports back on a pro level. That's the problem. That's the gigantic problem. And the bigger problem within that is the emergence of elected officials who have borrowed Jerry Brown's view of sports, which was, to me, pseudo-intellectual. In other words, I can't pay attention to sports because I'm too busy reading books or I'm too busy thinking high-minded thoughts. So what do I have to do about sports? When we start digging in to the raison d'etre behind that point of view, the sports that they point out that they don't like just happen to be the ones that employ by percentage the most Black people. Think about it. Everybody plays a sport. You do a sport. I don't care if it's running. I don't care if it's curling. I don't care if it's cycling. It's a sport. So when people say they're not into sports, I will tell you that's a lie. There's some sport they're into, but they don't like a certain type of sport. And when you dig down and say the NBA, they may not like LeBron James, but then what's that about? Well, they don't like that they say demonstrative. Well, he's really taking charge of his own business. In other words, he is an empowered Black man who refuses to be treated as a slave, a modern slave within the NBA. And by God, what's wrong with that? Absolutely nothing. You see what I'm getting at? We still have a lot of problems cognitively, such that we allow our own issues, some of us issues with being Black, negatively pour onto this matter of sports in Oakland. The reality is this. A typical Raiders game employed 2,000 people at various levels of sophistication. Security guards, on the one hand, cooks, musicians, managers, attorneys, police. You get the idea. A visit to Raiders game was truly a visit to a small city. And guess what? If you went to enough of the games and you were a season ticket holder, you pretty much knew almost everybody in the city, or at least they saw you once. That's how we brought our community together. But absent that, you tell me, you show me what other device we have that allows that effective of an interaction with people within a day among many thousands, 10,000, 20,000, 30,000. You say baseball with the A's. I say you're right. That's the last one. We don't have the Warriors. We let them go. But riddle me with this. Why can't we have an NBA expansion team in Oakland? Why can't the Bay Area have what New York has? New York is not much bigger than the Bay Area. The Bay Area can't effectively hold 2 basketball teams. Why is it that we have to have the one? There's nothing in law that says we do. There isn't anything in NBA law that says we can't have it. Why not another team, an NBA team for the Bay Area, for Oakland, our brand, in our colors? We don't have to beg the owner to call that organization something with Oakland in the name. Why not? These are things we can do, but we don't do. And so ultimately, all of this is really our fault. I'll be back later. Subscribe to Zenny62 and bookmark oaklandnewsnowblog.com. That is this broadcast.